I welcome you all to the new podcast, and it's a podcast endorsed by the Unwired under the aegis of the Quest. Today, we have with ourselves one of the renowned minds in the field of constitutional law and a great historian, Rohit Day. We welcome you, sir. And Rohit Day, sir, is a lawyer, historian of modern South Asia, and focuses on legal history of Indian subcontinent and the common law world. Apart from this, his field of interest are modern South Asia, including India, Pakistan, Bangladesh, global legal history, law and society, and law and colonialism. And the list just goes on. I'll keep it brief, and I think most of the people already know about you, sir. So we'll start with the topic itself. I'll start with your book itself, A People's Constitution. And for the very that idea, I'll start with the cover page of your book. If you know the cover page of your book, which I've printed specially for you, I wanted to know the history of this. Is there a narrative behind this also? Because as we read your book, there are narratives. So is there a narrative behind the cover of your book?
So most events have different layers of histories behind them. So I think the cover has sort of like three layers. I'll pick with the sort of big conceptual idea, right? Which is that the Constitution speaks in the name of the people, and the people as a kind of blanket category that doesn't have any particular marker attached to it. And through the book, we keep seeing how this idea of the people as a citizen, as someone who is not marked with necessarily caste, class, or gender, is a sort of actor that comes to court. So when you sort of discuss fundamental rights, unlike colonial India, where your rights were tied to your personal identities, the limited rights that you had. So you could have rights as a Hindu or rights as a widow, but you didn't really have rights as a citizen. So with the new constitution, you had this idea of an unmarked citizen come about. And partly what the book shows is that that unmarked citizen and particular people with like particular characteristics coexisted. So when we see a case that's about, say, it sounds like a very liberal idea of, say, freedom of speech, which is, should be available to everyone, and it's being brought forward as a kind of individual rights case, you realize that that rights articulation is only possible because there is a community at large whose interests are being attacked, and the community is mobilizing using a kind of individual rights framework. So that's the kind of, conceptual idea behind it. Pratap Bhanu Mehta had an interesting observation. So if you think of Hobbes's Leviathan, the cover has a picture of a giant with all these identical looking figures inside it. And in this way, this cover has, people look very different. The second sort of part of this is I was trying to find an image that would work. And I was trying to find, ideally, images of people inside courtrooms. Interestingly, those images don't exist, right? The photography of courtrooms are either empty places or judges. And lastly, this is the callous thing is, when I was a law student, my recreation would be doodling at the back of my notebook. So there were usually figures like this. And when I was sort of struggling with the cover, someone suggested that I should just, use my own artistic skills. So I felt this was sort of paying tribute to all those times in class where I wasn't paying attention but drawing at the back.
Right. So going through your book, one thing which is quite apparent there is something like is you're trying to tell a story from a middle class point of view. It's not a constitution of the higher upper middle class or the lower or the more lower classes or the marginalized group per se. You're trying to tell a story of a middle class person. So what made you realize that a middle class has a particular say in this? What made you think like that?
So, it's interesting to describe it as middle class. I've been struggling to find a term to describe it. So maybe one way to think about it is looking at the existing narratives that were there about the Constitution. So even when it was being written, the sort of Congress party or the group that was sort of leading it was making the argument that this is a Constitution that is really the first, unlike the kind of colonial government of India acts, a first constitution that empowers ordinary people. And the constant reference is in the interests of the people as a huge group. The state has empowered to do certain things. In a sort of break from, say, European traditions of constitutionalism, American tradition of constitutionalism, which looked at safeguarding rights of the people against the state, the Indian constitutional narrative was really about, in the interests of the people, the state needs to have these powers to transform our society and economy. So that's sort of one refrain that comes through. Right from the 50s, there have been a variety of groups been pointing out that how actually the Constitution was an elite product. It protected certain kinds of rights more strongly, such as, say, the debates over land reform and the right to property of large zamindars, particularly the left parties, but also other groups pointed out right from 47 that how the independent Indian state was using colonial legal mechanisms to target people's movements, particularly when these are movements of, say, workers and peasants, right? So there's a story that this is a sort of democratic window dressing on actually a very colonial constitution. So, and it's clear if you look at sort of court records, a lot of cases, I would even say significant bulk of cases, particularly civil litigation, comes from people with some access to property. But what struck me as interesting is in a number of spaces, you saw the emergence of these groups who are able to advance constitutional claims, mostly unsuccessfully. But you see that the use of the Constitution is not that they go to court and necessarily win, but the use of the Constitution is to sort of create a language through which you can articulate demands both inside the court but also outside the court. So the groups that feature in the 50s are what I would describe as two kinds. One is people who are electoral minorities. So these are groups in colonial India who had some access to the state. So let's take, for example, small traders, right? So there was the colonial government system of representation had these particular reserved constituencies for interests. So they had constituency for labor, a constituency for graduates. So they also had a constituency for Indian commerce, which was sort of native Indian businessmen who would get represented. Or they had religious-based reservations. So you had groups like the Parsis who had significant legislative representation. But after independence, with a kind of universal franchise model, these interest representation just go out, right? And these groups also become groups that are sort of attacked in the public sphere, even though they might possess some financial clout. They're attacked as not being good model citizens of the new nation. So the Parsis are seen as anglicized, somewhat effete, not nationalist enough. Small traders are seen as corrupt and are blocking the kind of move towards progress. And for these groups, the only space through which they can legitimately speak seems to be the language of rights in the Constitution. Right. The second kind of group is more interesting because these are groups that are traditionally excluded from political processes. These are sort of groups who are, I wouldn't call them middle class, but they are on the edges of the urban economy. So these are like the Qureshi butchers or sabziwalas, so they have some access to maybe small capital, but mostly their strength comes from the fact that they live in cities and they have some degree of organization. And interestingly, they've had a long history of dealing with regulation. So there's a certain degree of legal consciousness which, say, agricultural peasants, which are the largest part of the country, might not possess. And these groups become very effective actors in the 50s in mobilizing the courts and the language. So one of the kind of critiques or discussions of the People's Constitution has been that, okay, so you're showing it works for these 4 or 5 groups. Great. It doesn't work for the majority of the country. And in a way, what I want to suggest is this is not census, and this is not that everybody who uses it is in this book, but what it shows is that certain kinds of pathways open up. And it's interesting how these pathways get used later on. So a lot of the cases that come up around cases being brought by sex workers is on the question of what powers does a magistrate have to extern people from their neighborhood. And eventually, while the sex workers win some victories in the high courts, they lose in Supreme Court. But those precedents that they create then get used by groups later on in the 70s and 80s. And these groups belong to, say, a wider social category of individuals. So I think when you can call them middle class, you can call them sort of urban marginal actors. What they do is they're able to innovate or pioneer new methods of doing politics. And then these methods can be used and are used by other groups later on. There's a wonderful essay by Upendra Bakshi on Introduction to a Book on Service Law. And he says it's kind of weird that South Asia is perhaps one of the only parts in the world where there is this entire field called service law, and government servants of every rank go to court on almost every matter, from interview, promotion, this and that, right? And if you're like Bakshi or someone who's sort of progressive, you would see government servants as sort of cogs of the state. Why should their battle over promotion be of interest to the wider public? And what he says is that because they have both a sense of entitlement and an ability to litigate, what they do is they create a language and a pathway for claiming rights, which later on can be accessed by other groups. So, admin law really emerges with questions of promotion and interview, but it later on becomes sort of a tool when you're dealing with the state and lots of other fields, including sort of coercive ones.
Right. following on the same question, if you go through the book, we come to realize you're trying to draw a dichotomy between state and society. There are two entities, the state and the society, and the state is trying to regulate the personal lifestyle of every individual.
Yeah.
But in the same manner, you're also trying to say that state is a reflection of the society.
Yeah.
If you take the Marwari case or the case of the first chapter,
the prohibition cases, yeah.
Yes, the prohibition case. Somewhere down the line, though you have drawn a dichotomy between the state and the society, you're also trying to say the state is a reflection of society by evilizing the idea of Marwaris. The Marwaris are coming in between the progress of the nation. That's how the society is seeing them, right? So they are not welcome. So is the prisoners of society coming into the state idea also? So when the state is making laws of prohibition, is the state reflecting society in that perspective and excluding people?
Yeah, I think this is a really good question. It's something actually, colonial historians have talked about, but people working on post-colonial India haven't really explored, right? So in some ways, if we sort of think of our legal framework in India, right from the IPC, CRPC, these are all laws that are enacted by a colonial government, which is not integrated into social frameworks, right? And in fact, some of the logic behind something like the IPC is this idea that, okay, we're enacting this law for India, but really this law is a universal law that we can apply everywhere. And the IPC gets exported to East Africa, to Southeast Asia, to the Caribbean. So the main system of laws in India are, in 1947, have been enacted by a group that is not organic from Indian society itself. It's a group that sits outside. And in some ways, the mechanisms of government that they develop are based on this idea of separation from society, right? So, for example, there's a deep suspicion of lower officials. So the IPC says you cannot make a confession to a police officer admissible, right? Or there's CPC presents multiple possibilities of appeal because the colonial state assumes lower officials who are mostly Indians need to be, can't always be trusted and need to be available, need to be checked at all times. So with independence, we see a framework that was devised for foreign rule being taken over by a popularly elected government, or at least in 1952, a popularly elected government. And a lot of what the national movement had criticized in the 20s and 30s, and it's interesting when you look at them when they first come to power in the States in 38, the first things they do is they release political prisoners, they remove a lot of coercive laws, they reduce regulation. But in 47, they sort of hold on to these things. And their argument is that the problem is not the laws in themselves. The problem is the purpose they're being put to and the nature of government. And because we are an elected popular government, we come from society. We have society's interests in mind. And we see this narrative being followed even today, right? When we see legislation happening in parliament, which the argument is that we are legitimate because we are democratically elected. So irrespective of what we do to different groups, our legitimacy comes from society. So what gets constructed as society often is a majoritarian vision of what society should be. And we see this, for example, in the prohibition case, right? So prohibition is an interesting point where almost every social group seems to be in favor of it publicly. So there's a long history of successful prohibition campaign in Bombay. It brings together Hindus and Muslims who argue that, drinking is a foreign practice and it's against our religious beliefs. It is backed by Gandhi very strongly. It's one of the few things he's agreeable to state intervention on. The women's movement comes out very strongly in favor of prohibition. And when the prohibition gets debated in parliament and legislative assembly, the only people who object really are tribal representatives who argue it's alcohol as part of their religious practice, and one or two Parsis who are drowned out, right? So it's put in seemingly as a very popular law. The Bombay government creates special prohibition police. And suddenly you see like the impact of a coercive state. So by the mid-50s, there are tens of thousands of people who've been arrested for prohibition offenses. And these are not offenses that you were selling alcohol. These are offenses that might be that you are caught with an empty bottle or your breath was smelling of alcohol. So we see that while the law is seemingly popular, once it becomes implemented, it starts getting very unpopular in local areas. But there is no language through which you can oppose it, because all dominant languages of politics, which are rooted in culture, in nationalism, in women's rights, are unable to sort of challenge the fact that the prohibition regime is a coercive and brutal regime. So that's where constitutional law and civil liberties, perhaps pushed through by a self-interested Parsi community, provides a language through which you can challenge prohibition. It's very hard to challenge prohibition by saying that, this is against people's welfare, because, clearly everyone seems to agree it is for people's welfare. Even the economic reasons are sort of dismissed. But it gets successfully resisted when people argue that this is not about whether prohibition is good or bad, it's whether a policeman can enter your house and do a search of it without sort of taking consent, right? The interesting thing about this is, I mean, so, when I was working on the project, for me, these were sort of historic questions happening in the 50s. But Bihar enacted a prohibition law while I was writing this book, which is as coercive, if not more, than what happened in Bombay. And if you look at the kind of Bihar examples of like the raiding and the arrest, it looks very similar. And the high courts in Bihar seem to have forgotten these precedents. So it's an interesting place where you just sort of repeat the same patterns over and over again.
Going through your book again, it gives me an essence of the book of India Unbound of Guru Charan Das. And I guess you have read that, right? So
I haven't actually, but yeah, yeah, I know his work in general, but yeah.
Guru Charan Das, India Unbound, also talks about this idea of the state and society and how a strong state tends to discipline its individual citizens. And,
Yeah.
and in India, we have a strong society as compared to a strong state. Keeping that in mind, do you believe somewhere down the line that the idea of neoliberalism or the idea of human dignity is forcing individuals now to go to Supreme Court because they are not able to find adequate representation in the form of the parliamentarians, and they are using Supreme Court as a negotiating tool or a negotiating instrument to recognize them also as a part of the society? Can you see that happening here?
Yes, and I think what's interesting is in India, it's been happening for a really long time. So it's, there's some work which suggests that this move towards individual rights, groups using the courts to change policy is a sort of new phenomenon in developing countries starting from the 80s and 90s. It's a phenomenon that's pushed by sort of either neoliberal ideas on one side or on the emergence of international human rights sort of language. But in India, you see this happens from very early on. It happens right from the moment of independence. And there are attempts to do this even before independence, just that the language that the constitution offers or the powers that the courts have is limited. I think the one difference, and maybe we'll get to this in the conversation as well, is cases brought by individuals or groups on their own behalf and cases that are framed as public interest cases, where I bring a case not in my interest, but in the interests of like a third party or an ambiguous figure of the public. And I think these two examples give us, we tend to see them as the same, but actually they're quite different. And, scholars like Anuj Bhavani and Usha Ramanathan have shown the kind of dangers that the PIL model sometimes offers, where when the person affected is not in court and all you have is other people speaking on their behalf, it's not clear that the decision that's made is on benefit to these people. Secondly, I want to suggest that going to court is not society resisting against the state. In a way, the Constitution allows for more and more parts of society to become regulated by state actors, right? So, for example, when you decide to sort of challenge or support temple entry legislation, what you're basically doing is letting the state in various ways get more involved in temple management. Or when you sort of go to court and sort of challenge personal laws, yes, it's speaking the language of rights, but you're also allowing for religious laws to be more greatly regulated by state authorities. In this case, it might be the judiciary rather than the parliament, but it's not separate from one another. They kind of, in some ways, the Constitution allows, in a more subtle way, for the state to enter society than parliament.
Right. I would also like to go upon your style of writing, actually. So you have picked up a narrative style of writing, which is something which has been missing in Indian jurisprudence for a long time. So the Indian jurisprudence on constitutional law is more on article-centric. We write about an article, we pick up case laws, we write about them, and we just write about them a lot. So, and we suddenly see a lot of writers are coming up on constitutional law who are using this methodology of narrative writing, where they pick up a particular case, they give the narrative, either be a Gautam Bhatia, Madhav Khosla sir, either be Akash Singh Rathore sir.
Yeah.
So what do you think is supporting this cause of narrative writing suddenly? Why this sudden change is coming in the Indian jurisprudence?
So, okay, I think part of the story is who reads and writes about the Indian Constitution, right? So for a really long time, I think from the 60s onwards, there's a small period of the 50s where there are these first books that come out, which are perhaps less treatise focused. But from the 60s onwards, the main population that's reading and writing about the Constitution are really lawyers and law students. And then what becomes a popular way of writing is a treatise, right? Which is your V.N. Shukla is a great example. You have Article 14, you have like an explanatory point, you have highlights of case law, and then different editors edit that over a period of time. So it's largely seen as a user's manual, right, rather than something that engaged with more conceptually. The other group that studies is the IS aspirants, right, who are also studying it to be their exams. There's a little bit of work that comes out from political theorists, but most of the theorists focus on the assembly debates. There are a few people like, say, I think there's an old book by Rona Joy Sen, there's some writing by Professor Ratna Kapoor, Rajiv Dhawan and Professor Bakshi are like early examples of this, who try to write in a less treatise-like format. They're trying to theorize, they're trying to explain, they're trying to narrate. So what's changed now? I think there are a number of things. One is there is part of this is, I think it's not a coincidence that many of the authors you mentioned, Arun Thiruvenkatam is another example, so is Kalpana Karnabiran. One is this, I think, is a result of the 5-year law program, which was self-consciously modeled in the 1980s to integrate social science and law in the same setting, right? So law was not just seen as a kind of professional degree or vocational degree. It was seen as something through which you seek to understand and transform society. We all know that different places do it in a different kind of way and the results are mixed, but at least you're putting students in conversation with social science texts and law texts in the same setting. And I think some of that, at least in my case, is a result of that. Secondly, I think from the 90s, there's been a much widening interest amongst general public about the constitutional process. And I think especially the recent publication, boom. So apart from the books you mentioned, there are also lots of books by lawyers where just, here's a story of these famous cases, right? Is feeding that. And interesting, there is an older generation of these books from the 30s and 40s. So there's a guy called K.L. Gauba or Justice K.N. Karju. They all write these books about their famous law cases, and they sell really well. They sell in railway bookstores. They're these sort of popular books, and I think that genre got lost, and in some ways it's being rediscovered. And I think because lawyers are so focused on what did the Supreme Court say, and that's the final word, I think we're at a moment when there is some degree of confusion, skepticism as to whether the court's word on interpretation of the Constitution is the final word. Are there ways to examine and counter it that we can get from outside of the kind of precedent-linked jurisprudence? And I think the books that you mentioned are all ways of doing it, right? So in a way, Gautam Bhatia's book suggests that, yes, judgments are important, but it's not to be understood as by size of the bench and by weight of the precedent. You have to look for certain kinds of principles to understand how one moves forward. Or Madhav Khosla and Akash Rathore are like, okay, let's just forget about judgments, just go back to the 1940s and look at the Constituent Assembly and see what principles come through that. Kalpana Karnabiran's book is again a great example of like just using one article, which is 15, and trying to read a whole body of constitutional jurisprudence through that. The other interesting book is Arun Thiruvenkatam. It's a very slim book called The Indian Constitution, A Contextual Analysis. And one of the things he does there is that, we kind of treat the Constitution as a continuing text. And he argues that there's been a major shift in 1991 with liberalization, especially for things like regulatory institutions or assemblies and powers of the governor, which we haven't really thought through. So he's offering a different kind of periodization where it's not the emergency or independence, but really taking 91 seriously as a moment to understand what's happening with the Constitution.
Can we also say that there is a movement towards the realization of legal realism in India, where we are going to the idea of surplus information, not about only the judgment, but also the idea of the judge who's delivering it, what is sitting it, and I think that's one of the plus points which we're seeing in Indian jurisprudence right now, that we are having this surplus information with us.
So I think even in the past, this was definitely there in some kinds of writing. So there have been feminist scholars who've been talking about gender patriarchy in the judiciary for a long time. There's also been some analysis on class. I think the thing that's troubling right now is that you're not using legal realism through the lens of, say, class or things that are factors, but you might not be. They're not tied to an individual, right? They're factors that might describe a large body of judges. So judges are from a certain class, therefore so judgments usually represent interests of that class. What we are now getting to is that it's this judge, and it doesn't, it's not about the class or the community or anything she belongs to. It's just this judge and this particular judge's set of interests or philosophy, and we can even predict what the judgment will be once you know who's hearing it. And that's a very so legal realism, when it started, was about recognizing that the judiciary doesn't just operate through these formal rules. A lot of context influences how judges decide. But as you said, right now the context is sometimes so much and so clear. It's not really helping us make any kind. The legal part of realism is going. We're just getting realism when we look at some of the interactions. I won't say more given recent developments and contempts. Legal rules are not formalistic. They're not some kind of technical interpretation. There's a lot of context that's involved. And in Indian jurisprudence, to the kind of class or patriarchal interest of the judiciary to understand judgment. I think the difference with this movement is that it's not about features like class or gender. It sometimes it's this judge. And once we know who the judge is, we know what more realism and less legal, right? That's just a kind of power interpretation of the judiciary. And I think given our jurisprudence and contempt, maybe one shouldn't discuss it more. But I think legal realism requires that to be the use of legal language, even though the interest behind it has attempt to use the legal language to either consciously or unsubconsciously hide. But the kind of new information surplus that you're suggesting, I think it goes beyond what legal realism is.
Okay, yeah. So you have been to the basement of the Supreme Court of India, and you have been able to garner a lot of resources. Is there something which you have missed out or omitted in your book per se, which you think it should not be there? Or
so originally the plan for the book was going to have 8 chapters, and I was going to look at like more and more kinds of actors, and both sort of space and time constraints made me cut it down. I think the one thing, if I had more time, I would like to do is maybe add some quantitative analysis alongside it. So at the current volume, I sort of try and identify kinds of cases that are important based on public commentary or legal commentary, and then look for a cluster of cases on that topic. I think in some ways it would have been good to balance it with some kind of analysis of the larger trends. I'm glad that there's, and the other thing is, I think this very thing at the High Court, even in this book, while the Supreme Court is my primary archive, much of the more interesting radical stuff is happening at the High Court. And there are some scholars who've been working on the High Court materials. So Kalyani Ramnath, who is a legal historian at Harvard, has done this great project on looking at Madras High Court records in the 1950s. So I think there is prospect to do more of this research and also ask different questions. So I was trying to basically understand why is it that certain kinds of disputes become constitutional disputes, or why do ordinary people sort of enter the constitutional case? But people can ask other questions from the same material in that period. One of the things that I consciously left out was debates over land, which is the bulk of litigation in this time. Namita Wahi at CPR Delhi is writing a book on the right to property. She looks at some of this. But the thing with the land question is the land question, and there's land litigation that, so you can't do it just as a post-independence good. You really have to go back potentially and sort of follow trends around land and right.
Right. So one more question on this very idea is, how do you see Supreme Court of India as a negotiating tool in the last 10, 15 years? Do you think there has been change or makeshift in the stance of Supreme Court?
Sure. So I think one of the things that makes the Indian court hard to study compared to, say, courts in the US is that most Supreme Court judges serve very short terms, and the court is actually multiple courts because they're not sitting on bank, they're sitting in like smaller panels. So how do you identify a greater strategy through this kind of space? And I think one thing that's unclear through the work of Nick Robinson and others is that sort of central role that Chief Justice plays in leading the court, even though his term might be quite a short one. Right. And this is not unique just to India. If you look at sort of our neighboring countries, the position that Chief Justice has become highly politicized. Chief Justices have been removed or attempted to be removed in Pakistan, Bangladesh, Sri Lanka, and Nepal, and in India. There was an attempt to impeach previous Chief Justice. A lot of the sort of analysis is really on the role of those individuals. The second part about the court role, so the Indian courts have been really entrepreneurial in the past. So, for example, the courts have limited power. They don't have the power of the purse or the sword. How do you ensure your judgment is respected and followed? Usually, it's a set of three strategies. One is control of appointments, which the Indian courts had managed very effectively through the 80s and 90s. Second is to keep open the question of final adjudication. So, if you look at where basic structure is actually applied, the one thing they always rule basic structure, use it to rule things down on, is judicial review, right? So you can delete the right to property, you can delete fundamental rights, but you can't remove judicial review. So that allows the judiciary to have a kind of final say. And thirdly is a legitimacy through a language of either populism or transparency, ideally both, right? So either a judgment which sort of say really pushes back at the executive is justified by we're doing this in the interest of the people. And I think a great example of that is the right to information or right to food. And the second is really drawing on the language of certain kind of transparency. And I think on both these grounds, there's been a kind of shift maybe in the last 5 to 10 years where the 90s move, which focused on kind of populism and transparency, seems to have gotten a little muddy.
I think you have deciphered that quite nicely to a large extent. My another question is regarding the methodology of studying and researching, basically. So probably the education system or something is missing out with that. We are not able to create narrative-based research work in India itself. We are dependent on foreign scholars to give us our insight of the Indian jurisprudence.
So I think one of this is basically a structural problem, which I think you would be very familiar with, which is when you're teaching, who's going to do this work, it's primarily going to be done by Indian law professors. And if you're teaching in a law school where you're teaching 8 to 10 hours of classes a week, you are evaluating 80 to 100 end-term, mid-term papers, projects, and if you're doing it with even like the basic amount of attention required, you're not going to have time to pick up a larger kind of project like this. I think there are very few public law schools that even offer research leave to its faculty. There is a sort of shortage of resources, and so this is a deep-seated structural problem. And in some ways, the writing from India-based scholars that has come out in law has really come from social science faculty. So we look at people like Neerja Jayal at JNU or folks at Ambedkar. I mean, because at least the traditional university structure gives some leeway for research, which I think the law schools don't. And I think the design question in the law schools were they were designed to really improve law, and they weren't designed to, or there's some kind of structural issue that prevents them from becoming centers for active research. And I think it's a huge credit to those who are able to teach in the law schools and also do research. I mean, it's far more credit to them than to anyone who's based abroad and has all the time off and the sort of resources to travel and stuff. So I think that's one structure. I think there are positive notions of change. I think one is there's just a improving amount of writing from both law professors and law students in online and public forums. I think things like live law and my law have sort of opened up the legal system to wider commentary. It's not necessarily very critical levels of analysis, but just makes a lot of things visible so you can sort of pick up and comment on that. The Indian Law Review, for example, has been getting submissions, really excellent ones, from students in Indian law schools who are often able to spot issues much faster than someone who is not daily involved in what the Indian legal system is doing. Right? So it's great to have these like big narratives about the constitution, but sometimes you really want a very good sort of account of what's happened to one section of the IPC, which plays a major role in, say, deciding arrest. And I think law students will continue writing. I think the larger takeaway is to how to make it possible for faculty in Indian law schools to have enough time to do research and sort of get feedback on the work that they do.
Right. Actually, nicely pointed out, sir. Actually, at the same time, sir, a more broader question would be: do you think that that Indian academia or Indian jurisprudence has developed its own Swaraj? Have we come to a state that we can say, you know what, this is our heritage or something which we have contributed per se in the academia?
Yeah. So one is how do you define Indian, right? Do you mean And some people define it as you have to be within the boundaries of India and teaching in a public institution. Or do you mean people, scholars who study India or have studied in India at some point, or people who are not
Yeah.
scholars but are practitioners who are, I mean, some of the stuff you've done, I mean, there have been writers on Indian law and they're read outside of India. Certain things become visible. So Professor Bakshi, of course, is one of them. A lot of Rajiv Thapan's early writings from the 70s and 80s, I think, had that kind of effort. KG Kannabiran's Wages of Impunity, I think, is a really good way of thinking about how to use the law as a tool of resistance. And I think Indian feminist legal scholarship actually has been several generations ahead of Indian legal scholarship in general. So, they go into sort of not just descriptive questions of Indian law, but also basic questions. How do you adjudicate between rights of community, rights of an individual? What is kind of way in which, in a society like India, you can think about the role of, say, courts in sexual assault cases? Do we rethink questions of sort of consent and proof when we deal with violence against women? And I think a lot of that innovation comes out of the Indian context. The big push, of course, has been the sort of language of right to life, PI jurisprudence, locus standi. I think the issue was that for about in the 80s and 90s, there was a lot of writing that was very celebratory of narrative, and that got exported really well. So if you sort of go to Sri Lanka or if you go to Kenya, and they know this sort of jurisprudence, but I think the newer work, which is more critical of it, hasn't circulated as well. And I think at some point there will be a debate outside about what the actual impact of kind of PR movement was, and who did it benefit, and what are the things that worked and what didn't work. I don't think we've. So the question largely is, okay, why do we need Faraj in the Indian Academy? Absolutely, it should not blindly follow models outside, and it should raise questions that come from the Indian context. But I think given current debates and other questions, we might need to be more flexible about what and where we draw the border.
Right. Because you have written on the state and society a lot in the book. What are your thoughts upon the contemporary state? Is it more of a reflection of society, or in India, obviously?
Yeah. So I think okay, so one is we have to understand something is a kind of historical. The state is a historical project. So in the 1950s, the kind of legitimacy that the Indian state had is different from the legitimacy today, right? So in the 50s, you were for the first time putting all these territories that were governed by different entities under the same authority. You were also expanding state intervention in new areas of life. So, the tax collector shows up, but so does the vaccinating doctor and the kind of ASHA worker. And people were getting accustomed to the state entering these. One of the reasons why the Indian state was successful is that it managed to mediate both consent and coercion. So it was coercive in places like the Northeast or in Hyderabad initially. Saying universal adult franchise, and Orni Thani maps this in her book in really dramatic ways, was able to bring people into the conversation so they felt that they were participating in the state process. The state in the present is very different from the state in the 50s, which was trying to create legitimacy. The state in the present, in some ways, legitimacy has already been created, and it's trying to do new things. It's trying to draw on criminal law in newer kinds of ways, and I think the state will always say we're speaking the language of society. I think to what extent it does can't be judged. I mean, I won't enumerate them, but there are lots of conflicts between the visions of, say, the government and the ways in which citizens live their lives, right? Whether it's sort of a debate over a national identity card or Aadhaar, or it's a debate over citizenship bill, or it's a debate over new GST system, they don't fit easily with how most people live their lives. And one has to see to what extent is the state's imagination able to win over how society exists and sort of negotiate.
This is more on the idea of representation of the parliamentarian members. So,
Yeah.
as we already know that we have a very skewed representation in parliament. We have 0.03 MPs, 0.003 MPs representing 1 crore population.
Yeah.
In this scenario, when we have a very less representation, don't you think the Supreme Court is overburdened to be a negotiating tool here? That they have to negotiate with every right and make sure that they get representation?
So, I mean, this is a much longer conversation, but you're absolutely right in terms of like absolute numbers. The burden of representation on the Indian MP is quite high. There's also a larger debate to what extent is the MP able to perform his or her role given sort of strong anti-defection laws, the kind of weirdness of the executive functions of the MPLAD. I think there's also a design problem about how representation is done. So we've opted to go for first past the post, which often means that in multi-party contests, you only need about sort of 20% of the vote share to actually win your seat in a particular constituency. So how does one sort of deal with those questions of representation? I'm not sure the answer can be solved just by increasing the number of MPs. I believe that's being proposed and discussed. I think this requires a much longer debate, which some of our neighboring countries have had in different ways. We also, our judiciary is overburdened in many ways, not just because there's a massive shortage of judges at the High Court level, but also the kind of remoteness of the Supreme Court in Delhi from many parts of the country. And there have been some interesting studies recently by Aparna Chandra and others, which show how much of the Supreme Court's case law comes from neighboring states, and whether one needs sort of an intermediary court of appeals that sits elsewhere to allow for more space.
Yes, on that note, I think we can put this podcast on an end.